Good afternoon, everyone. At least for those on the East Coast, good morning everywhere else. I'm Trent Taylor, and I'm going to be sort of your MC for today's webinar. I want to thank you, first of all, for joining our webinar today. Really pleased to have you with us. As you know, we try to do these every few months to talk about new things or trends that we're seeing that might be good for those in the industry to be aware of. And we try to make it at least a little bit fun. As always, if you have questions, there's a Q&A function at the bottom of the screen where you can submit a question, and we'll try our best to answer the questions. And of course, if you don't have a question today but think of one later, our doors are always open. We love talking about this stuff, so feel free to email or call us anytime. So let's get started. Let me first of all introduce our panel, and here's our distinguished panel. Most of these faces are familiar because they've been involved in our quarterly webinars in the past. I want to give a special welcome to Kate Hardy, who is going to be joining us along with Royce to talk about regulatory issues. And just so you know, there's three of us today who are doing this in the midst of an ice storm, and that's Jenny, Ben, and I. So we'll keep our fingers crossed that our power doesn't go out. And I believe Royce is in Chicago, where I think he said they're getting apocalyptic levels of snow. So we'll keep our fingers crossed that we can continue with this today, but for now, the power is holding steady. Here's a roadmap of what we plan to cover. I'm going to start by talking about trends from 30,000 feet. Kate and Royce will be talking about regulatory issues. Ben will be talking about food and beverage labeling litigation. Jenny about product labeling litigation, and then Bethany, Prop 65. And the reason we put Bethany last is because she's been telling us that the weather out in California is 70 degrees and that, they're able to go swimming and that kind of thing. So we felt that deserves some punishment. All right, so let me start with trends from 30,000 feet. And these are just a few things at sort of a high level that I wanted folks to be aware of. And let me start with trend number one. Where are these labeling suits being filed? And this is something that continues to interest me. As most of you probably know, in the beginning, when this type of litigation first started, or not really started, but where it really metastasized and we saw a lot of them, those were mainly filed in California, especially the Northern District of California, which was nicknamed the Food Court. Now we're seeing a lot more of these suits filed in other places. Last year, for instance, there were a ton filed in New York federal courts, mainly by one plaintiff's lawyer who filed a lot of vanilla flavoring suits, class actions there. But in 2021, we expect to see a lot more class actions filed in the Northern District of Illinois and in Florida. And let me tell you why that is. So first of all, the plaintiff's lawyer that I mentioned that filed a lot of these vanilla cases in New York federal courts, he's taken a little bit of a beating. He has lost a number of motion to dismiss rulings. That's something that Ben's going to talk about in a little more detail in his section. But that particular plaintiff's lawyer has started filing more of his cases in other places other than New York federal courts. But one of the other things I guess I wanted to flag is that there's some new case law out there from various circuits that is class action friendly. And we have observed an uptick in cases in those jurisdictions. The first one I wanted to mention is the Bell decision in the Seventh Circuit. I'm going to talk about that in a little more detail here in a minute, but for the purposes of this slide, the takeaway is that the Bell decision is a good ruling for the plaintiff's bar, and we believe that makes the Seventh Circuit a more plaintiff-friendly jurisdiction for class actions. And we have an interesting stat on this. We looked at the number of consumer labeling class actions filed before the Bell decision was handed down, the 45 days before, and then we compared it to the 45 days after. it came down, and there were twice as many consumer labeling class actions filed after the Bell decision was handed down. And in fact, it's actually more so now. In the last 30 days or so, we've seen a ton of new cases filed in the Seventh Circuit. So that's something to keep an eye on. Another jurisdiction, the 11th Circuit. Earlier this month, they rejected administrative feasibility as a prerequisite for class action, and as a result, we expect to see more class actions filed in the 11th Circuit as well, especially in Florida. Okay. Another trend that I wanted to flag briefly is that there's a bunch of new baby food class actions. Now, Ben's going to give you the details about that, but what I wanted to talk about briefly is the genesis of those class actions. And essentially, it was a congressional subcommittee releasing a report about alleged heavy metals in baby food. And then, surprise, surprise, soon thereafter, we have 18 class actions that have been filed, and really a veritable plaintiff's bar feeding frenzy. And what's particularly interesting is none of the plaintiffs' counsel has done their own testing. They instead, in their complaints that have been filed, they rely heavily on the congressional report. So we expect to see a lot more of this, and it's going to be important to watch closely what Congress, congressional committees, executive branch, what they're focusing on, because that's going to set the agenda for future class actions. And if you have a congressional committee focusing on a particular issue, or a piece of legislation, or the FDA starting to do warning letters in a particular area, that's a red flag and a warning sign that you may see class actions come soon thereafter. So that's something to keep an eye on going forward. And here's just a list of those 18 class actions. That's something that we're keeping track of here, and I know a lot of other folks are as well. Trend number 3, quickly, industry-wide attacks. And this is something that I've mentioned in the past to a certain degree, but it used to be that the plaintiff's bar would have these one-off suits. They would try to find a manufacturer who had a label claim that was different from others in the industry, and they would go after, maybe pushing the envelope a little bit more, and then go after that particular manufacturer and file a class action against them. But now we have a new trend, and now they're focusing on claims that everyone in the industry are using, and then they file suit against everyone in the industry, or a lot of folks in the industry, simultaneously. We've seen it in ground coffee, vanilla flavoring, infants' medicine, baby food, and some other places as well, and we expect it to continue. And the takeaway from this is that you can't just rely on what others in the industry are doing, because you're not necessarily safe. Used to be you could maybe take it to the bank. If everyone was doing it, then maybe you were safe. Now, not so much. You need to be objectively looking at your labels yourself and not just relying on what others in the industry are doing. Okay, front versus back label is another trend that I wanted to briefly mention. And this, there have been several recent decisions on this. Some of y'all are probably aware there's a pretty famous case in the Ninth Circuit that a lot of plaintiffs' lawyers like to bandy about, which basically said that you can't have something on the back label to clean up any possible misrepresentations or deception of something that is on the front label. Well, we now have the Seventh Circuit, and this is that Bell decision I was talking about, who issued a ruling basically saying the same thing, that if you have a label claim on the front saying 100% Parmesan cheese, that can't be cured by having an ingredient list on the back label, showing that there are ingredients other than cheese in the product. So this reversed a dismissal at the trial court level, and I think makes the Seventh Circuit a little more friendly. Now, compare that with a recent Ninth Circuit decision that says that there does have to be an affirmative misleading statement on the front in order for that rule that we just talked about to apply. You can't just base that on an assumption. So in some ways, this is a very good decision because it clarifies what the standard is in the Ninth Circuit and kept the Ninth Circuit from having an even more draconian standard than it was before. And here's actually a decision where that is applied that just came out last month. And it's a trial court decision that demonstrates this front versus back label issue. And the takeaway here is that you have to look at the totality of the label and make sure that it is consistent throughout. All right, and the last trend I wanted to mention briefly is sort of a fun one, but there's a serious note to it as well. It involves the all-important issue of crab mix with a K and what it means to consumers. This was at PF Chang's on a menu, and the court held that crab mix with a K doesn't have a commonly understood meaning, so it's potentially deceptive. And the claim was that they thought maybe it contained a mix of imitation crab meat and real crab meat. And the court said, yeah, that's plausible, and the class action can go forward. As you can see, the dissent said, well, crab with a K should have been a dead giveaway. The takeaway here, though, this is sort of a fun one, and I enjoyed putting the Krabby Patty pictures on here, but the takeaway here is serious, and that's don't assume that a label claim can be humorous or tongue-in-cheek and that courts will protect you. Courts, as we know, often don't have a sense of humor, and it's important to do an objective risk assessment of label claims to make sure that you are not on the negative end of a class action. So that's the last thing I wanted to mention, and I'm going to turn it over to Royce and Kate.
Yeah, thanks, Trent. And we're going to start out just talking about some of the interesting trends that Kate and I are seeing both in the cannabis side of the world and within some emerging technologies and CBD. But I wanted to start talking about Delta-8 tetrahydrocannabinol. And, this is becoming a hot topic in cannabis circles. And there's a lot of misinformation out there about, what is the legality of it? Should we be adding this to our product lines? Is this something that we're seeing a lot of, but is this something that we want to have? And I think Kate and I would side on the position of Delta-8 is something that has a very gray legality around it, and there's a lot of law that would say that there should be a pause button on looking to acquire it or add it to products or sell it or transport it. And just as background, Delta-8 is a tetrahydrocannabinoid. It's just like Delta-9. It's one of the many different cannabinoids and tetrahydrocannabinoids found in the wonderful cannabis plant. And people that are starting to process Delta-8 synthetically are saying that, look, it's not Delta-9. DEA hasn't spoken to it. It's totally legal for now. Get in on the action and sell it and use it, and it's going to be the next best thing. But what those advocates are missing are DEA's final rule from last year, which specifically calls out synthetically derived tetrahydrocannabinoids, and a little law from the 80s called the Federal Analog Act, which, if you try to outsmart the federal government on creating a new drug molecule or a new way of formulating a drug that has hallucinogenic properties to get around existing drug laws, the DOJ, DEA will almost certainly find that it's a drug analog and pursue it under the Analog Act. And Analog Act analysis is extremely complex, and I have yet to come across someone that has convincingly told me that X substance is not going to be regulated under federal law as a Schedule I drug. Maybe it's out there, but I haven't seen it yet. So just kind of a pointer to keep in mind as big picture, if someone is marketing a new form of a cannabinoid or new, synthetically derived cannabinoid, hit pause think about it, maybe that's not the CBD you're used to seeing. The next thing that I kind of want to talk about is a little bit of, the future. There's a lot going on with, Elon Musk talking about the fact that Tesla wants to acquire Bitcoin, and, we've seen Bitcoin skyrocket to levels that are almost unheard of, $50,000 a coin. In a year, it's gone up tens of thousands of dollars. But crypto also has a place beyond just Bitcoins and Ethereum and cryptocurrency and Dogecoin. That's a Shiba over in the corner there. And it has a place in food safety. And USDA and FDA are already talking about how to incorporate digital ledger technology into food safety. And we've seen on the drug side, one of the big pushes years ago on the drug side was to bring about serialization, which is track and trace of human drug products from manufacturer to final sale in the pharmacy. And that was great, and it was really expensive. What we're starting to get whispers of now is that FDA and USDA are talking about using digital ledger technology, which is the same tech behind Ethereum and Bitcoin, and saying, how do we use that to make food safety better? And last year, FDA's Smarter Food Safety Initiative mentioned using digital ledger technology. USDA announced August 5th, 2020 in the Federal Register that they expect the future to include digital ledger technology to play an essential role in supply chain traceability. So what are they exactly talking about here? What they're talking about is having a license, and this is super simplified, but having a license plate that follows the food. But that little license plate that follows your food or your product is going to record every single transaction that came with that food and that product, as well as possibly the transactions of every other product in that ecosystem. And it's going to do it in a way that doesn't require a central server or doesn't require there to be an established network in place, but is going to interact with other food suppliers to track and trace the technology in a completely decentralized way. I don't know if FDA is really going to go down that full anarcho-capitalist route of decentralization, but that's the theory behind it. But what does it mean for you practically? I think practically what we're starting to think about is, clients should be anticipating that there are going to be new and advanced ways to regulate and track food beyond just what was in the past. And that new technology might be very powerful in tracking recalls and tracking food distribution, but it could also mean new requirements that need to be enabled. Walmart, IBM, and FDA recently did a large pilot study. Merck joined on that in 2019, and we know that FDA and USDA are actively looking at how this technology can be integrated into food safety. So our prediction for the future is that we're really going to see this come about, and it wouldn't be unheard of in 2 years from now for there to be perhaps a new advanced food tracking system that everyone is going to have to play in. And I'd say right now, start getting smart on digital ledger and Bitcoin and all that stuff in crypto, because that could become a really real way for you to start tracking your food in the future. The other small bit of future prediction that we saw was in August 17th of 2020, FDA had this strange Federal Register notice that came out saying that they're really interested in third-party audit standards. And what does that mean for your business? It means that FDA is starting to get really interested in whether or not the third parties that are used to ensure compliance under the Food Safety Modernization Act are really in harmony and in sync with what FDA wants. And I think what we're going to see from that is we're going to see enhanced requirements in the future about new standards that are going to be put on your third parties that are auditing your facilities, and FDA co-opting that process a little bit more. And, these are just things to think about in the future of, where is regulation going and what are the next big costs or next big compliance things that I need to think about. So I'd really focus on digital ledger, and I'd also start thinking about, are my third-party audits about to get more intense? And Kate, do you want to talk about CBD now?
Sure, absolutely. Thanks, Royce. On the next couple of slides, we wanted to just give a quick update and overview of the state of play for hemp and CBD products from the federal perspective and from the state law perspective. And as everybody knows, there's lots and lots of products out there on the market. And when we say hemp and CBD products, we mean products containing hemp or CBD derived from hemp in food, in beverages, in any other type of topical, a tincture, anything that you see out on the market. And from a federal perspective, not much from the FDA perspective has really changed or seems to be changing quickly at this point. The same position from FDA as from last year still stands. There's GRAS status for 3 different types of hemp: the whole hemp seed protein powder, and hemp seed oil. And that is it. I think there's still some misconception out there across the board that if any type of product is made from 2018 Farm Bill compliant hemp, it's completely legal to go ahead and put in your food or any other product, but that is somewhat forgetting that FDA has oversight of dietary supplements, food, pet food. There's been a lot of pet treats out there with CBD. And FDA still takes a very strong position as far as what can be put in these products. So I think that's definitely something to keep in mind. Everyone has been very hopeful, and there's been a lot more talk in the trade press that things are going to change quickly with the new administration. What we're seeing is definitely, what appears to be more movement. There's a lot more talk about it in Congress. We do feel that there will be more movement in the next year. We can hopefully look for some things to start passing, but it's definitely not going to be any type of light switch. So it's something to keep an eye on. And then the other thing that's very important to consider is the states are a complete patchwork of different requirements for ingredients, labels, permits, and licenses for folks that are trying to put some product out in the market. And we know from an FDA perspective, at this point, they are taking what's been called enforcement discretion, same from the Federal Trade Commission, which regulates just advertising. If you have a product on the market and you're not making aggressive cancer cure claims or other things, it probably at this point you can fly under the radar. But from an overall perspective, when you're thinking about product, not only do you want to be thinking about what's happening at the federal level, you want to pay very careful attention to what's happening on the state level, which is changing quickly. And unfortunately, at this point, many states are taking very different approaches to what they want to require and what they will be looking for specific products. So this slide is just an example of different states, what they are requiring right now. And one interesting thing I think we wanted to note about this, I've just got pictures here from several states. There's New York, Massachusetts, and Louisiana. The interesting thing about this is if you're looking for regulations and what's required in New York, those are coming out of the New York Department of Health. In Massachusetts, a lot of the regulations right now are coming out of the Department of Agriculture, so that's a completely different agency. And then in Louisiana, right now, we've got guidance and regulation coming out of the Office of Alcohol and Tobacco. So there's no one place at this point in every state where we can say, well, if I've checked here, I've certainly covered my basis on what I need to do. And again, the states are putting out regulations for food products, beverages, topicals, pretty much anything you can think of that you'll see on the market. A lot of it has been addressed in some of the newer guidances from the states. And one other interesting thing that we're also seeing is states are perhaps tweaking some of their definitions just a little bit for some of the bigger definitions like hemp, where we can look to the Farm Bill. Those are similar, but other states are taking slightly different approaches to some of the more nuanced aspects of these. So that's something to keep in mind. But just to cover these quickly, New York right now is very interesting. They've got a couple different types of permits, and you would need to look at those if you are selling product within the state of New York. Again, analyzing what New York may or may not allow. But New York also now wants you to obtain a permit if you are doing any type of retail sales through the internet for products that are coming into the state. So that is something to think about. Massachusetts right now, like Louisiana, is prohibiting any type of CBD derived from hemp in any type of food product. There are other products you could put out on the market so long as they are not making any type of therapeutic claims. Right now as well, Louisiana has a Cbd Dealer Permit. However, it still prohibits CBD in alcoholic beverages, food, or dietary supplements. And same thing in these states where you may have a product that's allowed. All of the states are taking a little bit of a different approach to labeling. So that's something else to pay very close attention to. Some states are looking for QR codes that need to be on your label. Some states are mandating specific types of disclaimers to be on products, and I think this is a difficult one. We see a lot with clients that people just assume if you put on what's called the FDA, the DSHEA statement that's normally on a dietary supplement, basically saying this hasn't been evaluated by the Food and Drug Administration and it's not meant to diagnose or cure or treat a disease, that you're fine. That is a disclaimer for dietary supplements, but again, what we're seeing now is states are maybe wanting some version of that or something a little bit different to be on the label. So takeaway on all of this, besides the federal overlay that we're all looking at, very important to understand every state that you're looking at, not only from, am I going to need a permit just because I'm selling product in there? Are there any other requirements about where I'm specifically sourcing ingredients, but also from a labeling perspective, which can be somewhat difficult, obviously, for mass production of labels if you've now got to try to have a different type of label on a product depending on your state. So we're keeping an eye on all this and watching developments in the state, but wanted to make sure everybody is aware as you're thinking about a go-forward strategy of how to be looking at it from both a federal and state perspective. And with that, I am going to turn it over to Ben, who is going to talk about the labeling litigation update.
Hey everyone, this is Ben Abel. I'm an associate in our Charlottesville office, and just going to talk very briefly about some major developments and major continuing developments, more especially in a couple instances for food labeling litigation. And there's a lot of interesting stuff going on in the world of food labeling, but there are kind of two or three big industry or at least ingredient / flavoring wide topics that are worth continuing to discuss. And so wanted to focus on those because, in a lot of instances, a lot of different manufacturers and producers are affected, and as opposed to some of the more interesting and cutting-edge areas that may involve only a specific segment of the grocery store. These have a wider reach. I also will apologize that the city has decided to plow my street at the exact moment that I started presenting. So to the extent you hear that behind me, I apologize. The first major topic I wanted to discuss is the continued proliferation of vanilla and flavoring suits. And boy, oh boy, I would love to not be talking about the vanilla suits and the flavoring suits again. We've probably talked about them on darn near every presentation for a year or so. But these are still out there, and against all odds or common sense, or for the most part, judicial opinion, they continue to grow and grow and grow. And so they're something that you need to be aware of. As Trent said at the outset, the vast majority of these cases are filed by two attorneys working together in New York. Spencer Sheehan and Michael Reese is on a number of them, but not all of them. But Spencer is kind of the driving force behind them. They started primarily as vanilla flavoring suits. So again, the allegation being that you sell vanilla almond milk, you sell the vanilla Greek yogurt, what have you, and the label says, the nutrition facts label, the ingredient list on the back declares that there's some flavor other than pure vanilla, either extract or vanilla bean, natural flavors, natural and artificial flavors, and according to the theory of the case, calling it vanilla almond milk, vanilla Greek yogurt is deceptive because that tells consumers that the only flavorant is from the vanilla bean itself. That theory has gone 0 for 6 from Article 3 district court judges in the Southern District of New York. Almost all these cases have been filed either in the Southern or Eastern districts of New York. And on motions to dismiss, at least, they've gone 0 for 6 from district judges, and there's another favorable report and recommendation that is cited here on the slide in the 7th case, which obviously is not dispositive and goes up to the district court judge. But they have not been successful. There has been one vanilla case, it's much more of an ingredient claim, that on summary judgment got past this positive motion. But on a 12B6 motion, the plaintiffs in New York are 0 for 6.5, essentially, which you would think would make this less of a desirable claim, or that it's time to move on. And we've kind of seen the exact opposite. So we've seen these flavoring claims expand past just purely vanilla to all sorts of claims. Smoked provolone, but the smoked flavor comes from an artificial flavorant as opposed to the smoking process. Cheddar and sour cream potato chips are a really big one. A bunch of different cheddar and sour cream suits have been filed. Same allegation. There's a bowl of sour cream and a block of cheddar on the label, but the sole flavorants for the chips are not real sour cream and cheddar cheese. Carrot cake that doesn't merely contain flavoring from carrots. Blueberry donut holes that aren't purely flavored with blueberry. So if you're flavoring anything like anything and using anything other than whatever that flavor is, despite the fact that the courts largely just don't agree with these claims, they continue to be out there. As Trent said as well, these filings have largely shifted the focus and center of food labeling litigation from California to New York. California remains incredibly popular as a filing place, but in sheer numbers, when we look at the filings on a month-by-month basis and what we monitor on a monthly basis, it's a lot of SDNY and EDNY at this point. So having a working knowledge of what the New York general business law requires and the New York causes of action, as well as New York counsel, of which McGuireWoods has some, but being prepared to litigate in New York as opposed to just thinking, well, we'll primarily be in California is important. Another important point from this is, again, despite the odds and despite the opinions stacking up, the footprint for these has expanded. Sheehan and Reese have started filing vanilla claims in California. We've seen flavoring of vanilla claims in Illinois as well. So they've packed up and taken the show on the road as opposed to taking the hint from New York. And we are starting to see copycats that pop up as well. So there were a couple vanilla flavoring suits that were filed in Massachusetts under Massachusetts version of their consumer protection. They weren't filed under the consumer protection law. There was an unjust enrichment count only, which may be a bit of a tough putt going forward for those plaintiffs. But again, despite all of the opinions pointing the other direction, flavoring suits continue to be out there and be kind of the dominant theme of what we're seeing, at least in sheer volume, on a month-by-month basis. The second thing, again, that I wanted to mention that Trent touched on is that the infant and toddler, both formulas and foods, have been targeted by the plaintiff's bar. Trent talked at the start about the House Oversight report on heavy metals allegedly in infant foods. That has sparked a massive rush to the courthouse from a number of plaintiffs' attorneys. There's not been just one shop that is really focused on these. If you go and read the House Oversight Committee report, right there on the cover page, it's got images of the logos for the brands that were covered by the study, which is a pretty helpful menu for plaintiffs' attorneys who are looking to find someone. And so heavy metals continue to be a problem for plaintiffs, for defendants, a windfall for plaintiffs looking to file. And as Trent said, these suits don't often involve independent testing. It's just, here's a House Committee report, and therefore, it's got to be in there, and we're going to sue you as a result. I think if there's a lesson to be taken or a road ahead, it's very similar to pet food, which I'm sure those on the call with children, the comparison to pet food and baby food probably isn't the nicest. But in pet food, one manufacturer put out a white paper on heavy metals in its foods, and there just was a massive a set of filings that followed and continue to follow, resulting at least in one MDL as to a particular manufacturer. But that white paper kind of launched was the report that launched 1,000 ships in terms of litigation. We'll be curious to see if the House Committee report does the same in this case, but it definitely has the potential to have some staying power. The other I'll talk very briefly about is there's been a transition infant formulas. There's been a series of claims basically alleging that manufacturers of these toddler formulas as opposed to infant formulas aren't necessary and aren't required and are duplicative of infant formula, and consumers don't really need them, and so manufacturers are being deceptive by even selling them. And finally, I wanted to touch on a series of coffee canister serving suits. These are allegations that the coffee canisters don't make as many cups of coffee as is allegedly labeled. Plaintiffs are saying that recommendations on the label as to how you could brew your cup of coffee are instructions that should be followed, and as a result would yield a set amount of coffee. And so there's been a series of those suits. It's been interesting to see that the segment leaders have followed some different approaches in this case. Kraft Heinz settled pretty quickly a nationwide class for about $16 million, while Smucker, who is the parent company for Folgers, there's an MDL and has fought these much more tooth and nail. More generally, I would say there's some outside of coffee, and if you have a coffee SKU, a ground coffee SKU, I would, this is of particular interest. But generally, if you've got makes X number of cups or servings or whatever on your label, and anything that could be construed as potentially instructions on how to make, it's something worth thinking about and considering, and thinking about what potential risk or exposure there might be going forward for litigation. We haven't really seen this claim expand past the coffee canister, but there's nothing to say that it can't be replicated for other serving suggestions, or if not instructions, at least ideas of how you might brew or make or cook a product. And so it's worth considering going forward. And with that, I will turn it over to, I believe, Ginny, who is next to go.
Thanks, Ben. Good afternoon, everybody. Thank you for having us. I'm here to talk to you about the product labeling litigation update and run through some trends that we've been seeing on the product labeling side. And a lot of the same themes from Ben's presentation will carry on into my presentation as well. So the first trend that we wanted to talk to you guys about is the natural claims. So the first case is out of the Eastern District of Missouri, Early versus Henry Thayer Company. This is a company that manufactures and distributes witch hazel, toners, and astringents. They label them as natural, and Ms. Early is claiming that, in fact, they're not all natural. They have synthetic or artificial ingredients in them, and unnatural ingredients that are in fact listed on the back, but it's in small, hard to read print, is what Ms. Early alleges, and that she paid a premium for the product because she thought that it was an all-natural product. She has brought claims for both a nationwide class and a Missouri subclass in the Eastern District of Missouri for violation of Missouri merchandising practices, breach of warranty, unjust enrichment. Thayer has filed a motion to dismiss and a motion to transfer the case to the Western District of Pennsylvania, but this is one that we will continue to watch and keep you guys posted on. The next is a very recently filed lawsuit in the Southern District of New York against Kingsford, who makes charcoal that you would use in a charcoal grill. This particular lawsuit alleges that Kingsford labels its charcoal briquettes as 100% natural, but they allegedly contain synthetic ingredients. So this 100% natural, or even just saying natural, as you see with the Thayer labeling class action, is something the plaintiffs have pursued in the past in the food labeling area, and it's not off limits, as you can see in the product labeling sphere as well. The next trend that we're seeing is not delivering on promises made. So the two examples I have of this are a class action that was filed in the Southern District of New York against Procter & Gamble for Crest toothpaste that is labeled as gum and enable repair toothpaste. And the plaintiff in this case is alleging that, in fact, the toothpaste does not repair gum, that gums can only be repaired through a cosmetic surgery, and that the claim for gum repair is actually false and misleading, and that it's actually also against what the FDA had approved in the proposed monograph for the toothpaste. So Ms. Neves has brought suit in the Southern District of New York for just a New York class action alleging claims of violation of state consumer protection laws, negligent misrepresentation, fraud, unjust enrichment, and to prohibit the sale of this particular product. So we will keep our eye on that one. There has not been a responsive pleading that has been filed in that Neves versus Procter & Gamble case, pretty recently filed. The next is an update on a claim or a case that we've talked to you guys about a couple of times. This one is out of the Northern District of California and involves Peter Thomas Roth and their skincare products that are labeled as Water Drench and Rose Stem Cell. And the two plaintiffs in this class action alleged that they do not actually repair or hydrate the skin as advertised or labeled. And it appears that this case has now settled on an individual basis. There's a stipulation that was entered recently that both plaintiffs' individual claims were, quote, fully resolved and hereby dismissed with prejudice, end quote, and that would-be class members' claims were dismissed without prejudice. So it appears for now that this class action has resolved on an individual basis. For those that have attended this webinar in the past, I'm sure you're surprised to hear me not talking about hand sanitizer or COVID-related products, but those also would fall into this sort of these sort of allegations of products not delivering on promises made, sort of, just keeping an eye on labeling and marketing, even, your websites and things like that, to make sure that the claims that are being made, particularly about the efficacy of your product, is substantiated and documented and true, because we are seeing still, hand sanitizers and other products. Trent talked about that Clorox case, the splashless Clorox case, earlier in our webinar, but those types of claims are definitely still out there, but we've spent so much time on them the past year, and everybody's spent so much time thinking about COVID that's not a formal part of the presentation, but definitely still part of an increase in class action litigation, sort of along the lines of, these allegations on efficacy or not delivering on promises made. Another area that we're seeing an uptick in class actions is this non-toxic label, and I'll talk about the different ways in these three different matters that we see this sort of generic non-toxic area being pursued by plaintiffs' counsel. But the first is in a claim out of the Northern District of California for a nationwide and a California subclass that was recently filed against Rust-Oleum Cleaner and Degreaser that stated that it was non-toxic and earth-friendly, and the plaintiffs are alleging that that's deceptive. That's a deceptive label because the cleaner and degreaser can actually cause eye irritation and skin damage. The motion to dismiss was denied in this stage, in this case. So it's moving forward, and we'll definitely keep our eyes and ears on this case and keep you guys updated on that. The other area that we've seen this is a case filed in the Northern District of Illinois against the manufacturer of Selsun Blue shampoo. It's alleged that the anti-dandruff shampoo contains chemical compounds that can actually exacerbate the user's scalp issues and cause hair loss. In the maximum strength Selsun Blue shampoos, and that the key ingredient, selenium sulfide, is well known to cause increased scalp irritation and critically hair loss, but that Sanofi is silent on the fact that the shampoos contain this preservative and the chemical that can cause the skin irritation. And so Ms. Lewis is seeking to represent a nationwide class against Sanofi for unjust enrichment, breach of warranties, injunctive relief, and also a violation of the Illinois Consumer Protection Act. And finally, very recently, just within the past few days, there was a claim filed against 4Life Products, LLC, out of the Northern District of California, where they're alleging that 4Life Products and their Rejuvenate brand of cleaning products are being labeled as safe for pets and kids when they allegedly can cause harm to humans and pets. That, again, was just filed, so there's been no responsive pleading and nothing done on that. But this is an area that we will continue to monitor and keep y'all posted on. All right, and then the last matter that we wanted to talk to y'all about is lab testing and just making sure that you have substantiation. I alluded to this a few slides before about, with the efficacy of your products and just making sure if you're making claims about it can kill viruses and bacteria, 99.9% of viruses and bacteria, or another claim like what's being alleged in this Blendtec case out in Utah, where the plaintiff is alleging that the blender had a 3 to a 3.8 horsepower rating, but in a lab testing that the plaintiff conducted that it only reached a 2.09 horsepower. This case was dismissed in partly because the plaintiff is from Virginia, but brought suit in Utah, and so the case was dismissed in part based on choice of law and also on preemption. And surprisingly, just as an aside, when I looked up this blender to put into the slide deck for you guys, I was surprised to see that it's a $1,300 blender. I was astonished by that. Must be a pretty good blender, but had never seen a blender that expensive. So I realized my time is running a little bit short. I'll pass it to Bethany, who's going to talk about Prop 65.
Hi, everyone. Greetings from sunny California. And while we often have bad news to report from California, weather is typically not one of them. So I apologize. I went a little full and heavy with the theme today, so the titles are a little bit cheesy, but bear with me. We have some important news to report on Prop 65 in California. So in January, OAHA went ahead and proposed some substantial changes to what we all term the short-form safe harbor warnings. Short-form warnings have been a sort of go-to easy way for manufacturers to warn of the necessary potential exposures in California because the short form, it's short, it's easy, and it doesn't require identification. Current short form safe harbor warnings do not require identification of a specific chemical, only a chemical pathway. California has not been, and OAHA has not been happy by the way that manufacturers have embraced the short form warning and have been using it, and have claimed that it has resulted in overwarning. I'm not sure that the short form has resulted in overwarning in California. I think it's more that the very active plaintiffs bar has resulted in overwarning and corresponding failure to dismiss cases out of our courts. But that said, they've put forth, some pretty wide-ranging changes. There are new limits of when a short-form warning can be used, new content requirements, and we're going to get into those a little bit in more detail. Any written comments, in case you're interested in providing written comments to these proposed changes, are due March 8th, 2021. And there is somewhat of a runway associated with these proposed regulations. They have to go through the notice and comment phase. Once they're approved through the notice and comment phase and finalized, they then go to the office, the OAL, for final review, and after they're approved there, then it's a 1-year time period that you can still through manufacturer and label before you need to change your warnings. That said, that time will go very quickly, so you should, I think it's important to start looking at these issues now. So first of all, when can you continue to use the short form safe harbor label? You can continue to use it if you manufacture or sell a small product, and small products is defined as the total surface area for consumer information is less than 5 square inches, or the package size and shape cannot accommodate a full warning. So that's a pretty small product. However, OAHA has said that presumptively on food products, it is okay to continue to use a short form warning as long as that warning is set off in a box from other surrounding information, and so it's sort of set out and visible. You can no longer use short form warnings on the internet and catalog sales. So previously, if you had had a short form warning on your product, you could also use that short form warning in your catalog or on the internet. And California has said you can no longer do that. So here's where sort of the rubber meets the road here. Again, in the prior version of the short form, which you can see here under old, an example of a cancer pathway warning, you didn't have to identify a specific chemical. So I think there was a tendency for manufacturers to rely on this short form because they didn't have to put a scary chemical out there for consumers to view. And you also didn't have to be specific about which chemical might arise to a level that is significant enough to require warning. And so it eliminated some of the need to really look upstream to your ingredients and really, do a lot of product testing to determine whether or not your chemical, even if it appeared in your product, was at such levels that it needed identification and warning. The new proposal requires this identification of at least one chemical per pathway. So again, there is a cancer pathway and there is a reproductive harm pathway under Prop 65. And if you have a chemical that only leads to potential cancer according to the listing, then you list it under cancer. If there is a chemical that leads to potential reproductive harm under California's listings, you list it under reproductive harm. If there is a chemical that satisfies both, which some do, then you can combine and use one chemical for both pathways. Otherwise, you have to identify one chemical per pathway. And so that really sort of elevates the game with respect to Prop 65, and it is going to require a very close look at your ingredients and really the levels that you are using those ingredients in and demand additional attention. Two follow-ups here. One is that, sometimes OAHA and the AG actually step in to help. I think a lot of manufacturers see these 60-day notices and believe that, California really isn't taking a look at them, that they're just passing across the AG's desk and nobody's really paying attention. I obviously think lobbying plays a role in that, and there are some industry efforts to get the AG to act in certain industries. But this example here with dark chocolate and chocolate manufacturers is just one example where the AG does step in from time to time and tell plaintiffs to go back off and go home, that their claims cannot be substantiated based upon the evidence that exists. And here's an example. This was dealing with dark chocolate and lead levels in dark chocolate, and there were a variety of 60-day notices sent out about that. And then finally, I'm going to end with a recent Ninth Circuit case last fall that deals with substantiation claims. I raised this just because I'm having to deal with this case a little bit with the plaintiff's bar, who have misinterpreted basically the burden of production and proof here in California. So if you make a labeling claim, a private plaintiff can't demand that you substantiate your claim under the law and just sue you and say you have to substantiate your claim. What a plaintiff can do, however, is sue you with direct studies or information saying that your claims are false or misleading and challenge your substantiation. And this case, in addition to talking about some specific preemption issues over structure function claims and also implied disease claims, which are an interesting read but very technical, very much associated with preemption and the Food, Drug, Cosmetic Act, it also reiterates this sort of burden of proof and burden of production, which remains on plaintiffs. So it's not enough just to have a plaintiff in California. You can't just say, that claim's wrong. You have to come forward with some sort of evidence that directly contradicts that claim, and then you fight it out basically as a battle of the experts to get past it. So I think that this is an interesting case. It's a good read, and I would refer you to it out of the Ninth Circuit. So I know we have finished our time. I just wanted to say that with these changes in Prop 65, I know a number of you are going to be taking a look at this with your teams. It's ironic that OAHA, in its sort of statement of reasons, said, well, there's no big deal about this. It's not going to have a significant economic effect on manufacturers. And I think they're dead wrong here. We all know it takes a tremendous amount of time to make label changes and to look at this information and go back and look at your ingredients and your products and do testing and substantiate various levels in your products. So our team here is here for you out in California, and we'd love to help you out with that work.
All right. Well, thanks so much to Bethany and the rest of our panelists. We hope you've enjoyed our program today. And as always, reach out if you have any questions or if there's anything that we can help you with. Thanks a lot and have a good rest of the day.